Good evening. This is Laws 11046, Environmental Law, and it's week 3. We're dealing primarily with the executive branch. Just a reminder, there are a few videos which I've recorded. They're on screen on Moodle and for the most part on UCrew as well. I'd ask that you please keep up with viewing those, and each week I'll provide you with my critique of various chapters from Bates' book. And I do expect you to read the chapters. What I say is merely to supplement what is written in the text. And I guess it's my take on what is most important in my view. You may disagree, or you may choose to perhaps view or listen to what I say in conjunction with reading the material. There are some other videos that you really do need to look at. There's one which deals with legal research. Kelly Stidiford provides some commentary in that regard. And I do talk about, in some of the videos, things like thinking about a lawyer and the study of law. Very importantly, have a look at the content in terms of how you go about researching for legal studies. And that will give you a good idea as to how to find information which might be difficult to find. I have provided some commentary in relation to how to access Hansard's. So hopefully you've had a chance to look at that as well. All right, so moving on to tonight, I would like to firstly talk about the way in which lawyers write both assignment work and papers, and you'll see this reflected in Gerry Bates' book. You'll see it also reflected in the cases that you read and general legal commentaries. So if you're after an idea of how to write your assignments, then perhaps I would suggest you look at that. Most of the referencing that you see in cases and in the legal commentary, certainly in Bates, is based on the Australian Guide to Legal Citation as opposed to Hansard. In this course, I will accept either one, but I'm more familiar with the Australian Guide to Legal Resources, citations rather. In essence, a couple of things to mention. That is, generally speaking, we use footnotes rather than having referencing in the body of the text, but either is fine. The other thing is that you'll see when we're referring to a case, we refer to the legal citation and we don't refer to the internet source. So I'd rather in your assignment you didn't put www.ostley.such and such and then the case citation. I'd rather that you make a reference to the specific case as its legal citation does appear. So if you're talking about Predajon case, refer to it in that manner, which is provided to you in the assignment itself. All right, so you've had a chance, no doubt, to access legislation. You've had a look at the way in which cases can be accessed, and I've also provided those commentaries, as I said, for each chapter as we go through. The executive. Chapter 2 of Bates' books does provide a lot of commentary in relation to the executive. I won't repeat what I said in the earlier Zoom session, but I just will mention that the Crown is a concept which stands aside from Parliament and stands aside from the government. And I think in one of the other commentaries I made reference to the fact that the Crown is a bit like the concept of the household. In a family type situation, members of the family can come and go, kids grow up, they leave home, so they're not part of the people that are the family living in the home, but there's this concept of the household, if you like, or the family household, which stands a little differently to the individual members within it. So when we're talking in the context of environmental law, you'll often see a reference to the Crown. The Crown owns the land, which is then subject to a Crown lease, or the Crown owns the land, which is then given to a private landowner, which is a deed of grant of land, or something of that effect. Or even on a title deed, if you own freehold title, if you have a look closely at the reservations, it will say that you are the owner of the land, subject to reservations in favour of the Crown, which will include, for example, entitlement to mineral rights and petroleum. So just because you own real estate, that doesn't mean that you own everything below and have the right to anything above. It is subject to that overall reservation in favour of the Crown, the household, if you like. So we've talked about parliaments, we've talked about the way in which parliaments are elected, parliaments make the laws, and we've talked about the judiciary. We've talked about common law, the way that judges make the law, and certain decisions then binding on judges down the track. So there are two ends of the spectrum and separation of powers, and I guess they're relatively easy to understand. But it's the part in the middle which is perhaps the more awkward part, and that's the executive. And that's the focus of tonight's little talk. So, in essence, a responsible government is one where there is accountability of the executive to the parliament. So the executive is the body which administers and deals with the way in which laws are implemented and administered. So the executive is responsible to the parliament, and parliament, of course, is responsible to the people and subject to change during an election situation. There is some constitutional law tied up in this, and that is that ministers of state must come from Parliament, or that is the House of Representatives or the Senate. So there is a crossover there that elected officials, that is ministers, are actually the people who are in charge of the executive for their particular area of function. So those of you that might work in the public service or have dealings with the public service may be familiar with the term a ministerial, which is where there's a directive, if you like, or a question being asked by the minister who is in charge of the executive. So that's section 64 of the Constitution, which provides that the head of the executive must be a member of the Senate or the House of Representatives. So the executive deals with a whole range of different agencies and authorities that administer the law and execute the law. And that will change from time to time, but the members who make up, the people that actually make up the executive, by and large, are a group which are more long-term than those that are involved in Parliament. So Parliament, of course, is comprised of people that are voted in, subject to removal every 3 years. Members of the executive are normally either on a contract or employed on a full-time basis, and so they have a greater degree of tenure, if you like, and security than parliamentarians. But beyond the executive, we have the judiciary, and they have the greatest job security and tenure. So they're only to be replaced in certain circumstances. All right, so we've talked about the basis of the separation of powers is in the Constitution. You can have a look at that if you like. Have a look at section 61, and that deals with the executive and how that executive comes into place. So if you like, the executive is comprised, apart from the minister who is in charge, of essentially public servants. And their role is to act upon the law which is imposed upon them, and from time to time, in the reverse situation, provide advice and recommendations to Parliament. Many of the roles which were traditionally taken up as part of the executive have over time been privatised, either by way of contract or complete privatisation. So Telstra, for example, before privatisation, was part of the executive arm of government. Likewise, the Commonwealth Bank was part of the executive. There are, in many instances, separate organisations or commissions which are set up as part of the executive. For example, the Australian Competition and Consumer Commission is a statutory authority, well known, which is part of the executive. So, in essence, the executive is everything other than the Parliament and the court systems, but there are some crossovers. Executives, people who are administering in an executive function, are required to make decisions from time to time, and you'll see that often in environmental law. So in that sense, they have something like a judicial power. It's not a judicial power, but it's, if you like, a quasi-judicial power, that is decision-making power. On the other hand, the executive can sometimes have what's called delegated power to make legislation, delegated legislation, and that's essentially where the Parliament decides to enact an overarching set of laws and allows the executive, through this power of delegated legislation, to fill in the gaps, as it were. So there are some crossovers, and the reason I'm stressing that is that from time to time you need to consider, in the context of environmental law or planning law, who is actually making these decisions and in what capacity. All right, so for example, if we look at chapter 2 in Bates' book, there's a considerable amount of reference to the question of whether compensation should be paid in circumstances where there are decisions made that are environmental in nature. So if, for example, the executive branch of the government, through one of its agencies, introduces or makes a decision about the imposition or otherwise of a license, then the question is, what rights does the affected person have in relation to that decision that was made by the executive? And coming back to the Constitution, you would have seen that the Constitution does provide that in circumstances where property is taken from an individual, then that person must be compensated on just terms. Those of you who've seen The Castle will remember that term, which was the hallmark of that particular movie. But the question is, considered in Bates' book, what actually is property? So if, for example, someone has a stream running through their property, or even a river running through their property, do they have the right to effectively fence the river and claim anything that's in the river for themselves? Or do they have the right to draw from the river as much water as they want? Now, under the old common law, the answer would be that a person is entitled to use whatever's on the land for themselves, and provided they're not causing a nuisance to others, they have that right and entitlement. So environmental law is all about the creation of laws which impose restrictions for the greater good, but that comes then with the question of how and when are people compensated in circumstances where they may be affected by that. All right, so that's all I propose to talk about in relation to the executive and chapter 2 of the book. If there are any questions, please let me know. Are there any questions from anyone live, or does anyone wish to ask a question through the chat facility? All right, well, I'll move on. And if there are any questions, just let me know. You can always use the chat facility. All right, in the notes in Moodle, you'll see that there's some commentary in relation to the Sustainable Planning Act. Now, the Sustainable Planning Act is, of course, the key piece of legislation in Queensland. And from a planning perspective, there are different functions which are to be fulfilled by different authorities, and they have different powers to do so. So Parliament creates what's called the state, regional and local planning documents. The development applications, which are then presented for consideration, are dealt with at this executive level that we talked about, and decisions are made at the executive decision level. And those development applications are then considered in accordance with the Integrated Development Assessment System, IDAS for short. So have a look at section 230 of the Sustainable Planning Act in that regard. So I would ask that you do have a look at the Sustainable Planning Act to get a feel for the way in which planning processes are dealt with through the executive, and that has a bearing on environmental law, of course. So the Parliament makes the legislation, the executive then considers these development applications, and parties that are unhappy will then go to the court and seek a judicial outcome. And that's what we saw in the Preda-John case, exactly that situation. Someone who was not happy with the decision of the executive took the matter to the judiciary for consideration. Just be careful that from a planning perspective and an environmental law perspective, that not every decision can be subject to a legal challenge, and sometimes the decision is not to be determined by the judiciary in the usual sense, but it's to be determined by way of a judicial review or a merits review. So there are different recourses for an aggrieved party that may apply depending on the question that has been asked. So that's really a case-by-case situation, but I'm just raising at this stage the point that you can't necessarily go to the Planning and Environment Court to seek redress in relation to every matter which is environmental or planning in its nature. So I've made some comments on Moodle about what we mean by the merits appeal as opposed to the judicial review, which is another aspect that we'll talk about in more detail later. So I appreciate that's a very quick overview, but I'd ask that you please have a look at the Sustainable Planning Act, have a look at IDAS, just get a feel for that in general terms, and hopefully that will then make the discussions in the case law a little bit more relevant. Last week we talked about terra nullius. I don't propose to go into that in any greater detail, but I think you've got a feel for how that might apply in your discussion. So I think that's all I'll do there. Now, are there any questions? No, nothing yet. Okay, let's talk about the assignments. Firstly, the second one, dealing with legislation. So the idea is that you have an ability to read an act and get a feel for what it means, get a feel for the way in which it is worded in an environmental law context, and then make some comments in your assignment work in relation to it. It's not meant to be a hard exercise. It's really, don't look too deeply at it. This is a piece of legislation, and I want you to talk about it, essentially, in the assignment work. But it's also important that you understand that these things don't appear in a vacuum. There is always a lead up to the creation of legislation. Now, I could go into the way in which it's created from a technical point of view, which involves essentially a document which is drafted, then presented for a first reading, possibly a second and third reading, and then at a federal level goes through to the Senate for consideration. It might bounce backwards and forwards, etc. But once it's passed through both houses, it's then subject to an assent and it becomes law. So that's kind of a mechanical thing. And you can look on the internet and find some nice flowcharts which show the way in which the laws are created from a technical point of view. But part of the exercise in the second part of the assessment is actually getting to know Hansard, how to find it, and what it means in the context of a lawmaking. So sometimes, from a statutory interpretation point of view, it may be that a certain word or phrase needs to be interpreted. And one way that we can consider as lawyers interpreting that material is to go back to the original arguments, the original speeches in Hansard, or the explanatory notes which were created to better explain the law and better explain the context in which the law was made. So in that sense, Hansard's useful. Now, from an assignment perspective, it's great, because what you've got in Hansard are answers to all the questions such as, why was this law introduced? What were the issues that were considered relevant that needed to be addressed in the law? What were some of the solutions that they came up with at a parliamentary level to deal with those issues, and where is that incorporated into the law? And what were some of the things that they decided to leave out? In what sense does the law repeal the previous law? There's a whole lot of information, if you read Hansard, that might help you both to understand the legislation itself and also to better comment upon it in an assignment context. So that's so hopefully you've all seen that link that I've given you to Hansard. But just have a little look around there and just get an idea of how you might use that in all your other environmental law and any other law subject that you might do. All right, so that's probably all the hints that I want to give to you in relation to assignment 1, part 2. Are there any questions that flow from that? Anything you don't understand? Have I gone through it too quickly? All right. Now, assignment 1, part 1 deals with Preterjon. So, you know, we talked about the fact that our environmental law is comprised of statutory law and case law. So that's why you've got an assignment on a statute and assignment on a case. So in Preterjon, a couple of things to look out for. The first is that there's some excellent comments made by Rod Litster QC, who was the lead counsel for one of the parties in that case. So my interview with, or my discussions with Rod, are actually very specific about his involvement in this case. So if you want some background detail, have a look at that Zoom video. I think from memory it's in Moodle weeks 2 or perhaps 3. Apart from that, the way in which lawyers write, I'll give you an acronym, and it's IRAC, I-R-A-C. Another one is CIRAC, C-I-R-A-C. It's essentially the same thing with one word tacked on the front. IRAC stands for, firstly, issues. R stands for rules. A stands for application. And C stands for conclusion. And if you follow that type of format and that thinking, you'll see that's how many legal commentators write. So I are the issues. So when you're reading a case, try and identify what are the real issues here? What are the legal issues that are relevant to this case? So as you read something, you might think, well, is that part of the legal issue? Is the legal issue to do with, contract law, or is it to do with offer, or is it to do with criminal law? So what are the issues in the case? Then once you've identified what the legal issues are, you then recite the rules. So it might be that you've come to the conclusion that this particular problem, let's say a legal problem, is all about contract law, and it's about whether there was an offer and an acceptance. And you might say, well, that's the legal issue, offer and acceptance in the context of contract law. Then the second part is R, rules. So you might then state, for the benefit of the reader, what are the rules in relation to offer and acceptance in the context of contract law. So you'd say, well, for there to be a contract which is binding, you must have an offer, you must have an acceptance. Here's what an offer is, here's what acceptance is, and here's my authority for saying that that's what is the law, that is the law. So it might be a reference to a case, or it might be a reference to some statutes, etc. But so what you're doing is you're setting up what the rules are. So firstly, you've got the issues. This is the legal issue, or these are the legal issues. And then below that, you say, okay, here are the rules. Here's how the law, this is what the law says. Now, the next step, the third step, A, application, is how you tie the two together. So you say, this is a case where the issue is to do with offer and acceptance. Here are the rules. Now, in this particular case, here's how the rules are applied in these circumstances. And then finally, the fourth step is the conclusion. And the conclusion could be quite short, or it can be quite lengthy. So it might be, the conclusion then is that in this particular case, there is no legal acceptance of the offer, and therefore there is no contract. So you wrap it up with, this is my conclusion. Now, don't get too hung up about that. I've said previously, there's no necessarily going to be a right and wrong answer. There might be, but I'm really interested in the way in which you identify what the legal issues are, you identify what the rules are, and then how you go about arguing the way in which the rules are applied in the circumstances, and how you go about arguing what the conclusion is. That's really the most important part. There are a couple of variations to the IRAC method. One is the CIRAC, which is where you state the conclusion at the start and then you state it at the end. Otherwise, it's the same in the middle. So CIRAC. Another one, and I quite like this one, is MIRAT. It's M-I-R-A-T, or MIRAC. And really the M just stands for material facts. So I think that's not a bad one. And if you're looking at the Preterjon case and you tried to adopt that line, that type of thinking to the way in which you write your answer, you might start by saying, look, the material facts in this case are that there was a parcel of land, someone applied to develop the land, the application was considered by the council, council imposed certain conditions, the developer had tried to address those concerns in the development proposal. Ultimately, the developer was not satisfied with the terms of the conditions that were imposed, and as a result went to court. So you might say, well, they're the material facts. It's like a summary, a snapshot, so the reader can say, oh, okay, I know what this case is all about now. You've just told me. They're all the important things. And then you go on and talk about the issues, then you talk about the rules, then you you talk about the way in which the rules were applied to the facts and the issues, and then maybe state the conclusion. So using that type of technique might just be a good way to write your assignment. It's not the only way, but it might be a good way. Now, of course, there are sub-questions in the assignment that kind of get in the way of that type of writing, but you might be able to incorporate it, and I'll leave you to consider that. All right, I've been doing a lot of talking. I'm trying not to make these videos too long. So this term, I'm really trying to break them down into more workable lots. Now, that said, I'm not trying to put you off asking any questions, but unless there are any questions or comments, that would be the all that I really wish to discuss tonight. So while I'm waiting for you to formulate your questions, either by using the chat facility or coming in live by just unmuting your microphones, just a reminder that I'd like to see uCrew used, I think, a lot more than it is being used now. I am getting a few questions which are being sent to me by email, and that's fine, but I'd really prefer that those questions, by and large, were sent to me via, or were raised in uCrew. That way I can provide an answer so everyone can see what I have to say. And indeed, what I have to say may not be what others wish to say. Others may say, well, no, I think this is the way it should be, or I think this is the appropriate answer. So uCrew is a great way of engaging in some discussions. So I think it's being underutilized, folks. So I'd like to see that being used a bit more in the future. All right, so are there any questions? Final call for any questions. Doesn't look like it tonight. You've all been very patient and quiet. So I'll stop the recording now. Thank you.